So tell me.
A review of the body cam, we did see the failed signal. In addition, we did see the high mounted brake light out, which is a third brake light. And under the Texas Code, section 547.3215, the federal vehicle equipment safety standards are adopted. And federal regulation 49 CFR 571.108 requires a high mounted rear brake light. And because that was out, that is the.
But not all cars have that.
What?
So are you telling me now every single car has to have that third mounted brake light?
It requires any multi-purpose passenger vehicle, which in this case it was a sedan. So in this case, it is a passenger vehicle. So it has to have, and you can see on the body cam, Your Honor, you can see the high mounted brake light. That's not a truck, not a sedan. Well.
And I would point out, sure, it requires the vehicle to have.
No. But did you really see that there's no turn signal?
There's no turn signal and
I would like to see that.
yeah, we can see that it's,
Can you show him what you saw, please?
yeah, because she can pull up the video faster than I can.
We had the video already.
Oh, okay. I'm stamped at 0.08. It's signal. You can.
So you're gonna see the vehicle come into view at a distance right there, and he comes across 2 lanes without signaling.
Bro, you can,
Come on, Will, you
we
can.
can show the judge that,
Yeah,
because you can't.
we
you
can
can't
step in
see
the
that.
back and you can see
I
it
don't think
cut
that's
across.
him.
There's no way.
There's no way that's him because
But-
he's already in the furthest right lane by the time that,
No, you
in
can see
2
him, you
seconds
can see him
later.
going across to his right, a lane without any signal and addition to that brake light as you continue the video.
Would you like to see, Judge?
Sure. Let me see.
You will see your.
Which car?
It's a, may I, Your Honor, go up there and point it out?
The truck.
No, it's the gray sedan. The gray sedan come up.
Oh, it hasn't come up yet.
You won't see it until after the law enforcement goes over the hill on that.
It looks like he's going pretty fast, huh?
No, we're just.
There is people kind of.
So when you go, I mean, the law is such that you're always supposed to signal, right? And I mean, even if you're going in that turn,
Well,
I mean, were the lights on at that point or no?
yes, the lights were on as soon as he gets up to the back of my client's vehicle before he makes that turn, Vegas shape lights. And the state is saying that there was an unsignaled lane change fire.
How do you know the lights are on?
Pardon?
How do you know?
Because the sound kicks on, you can hear it.
Yeah, and he's correct that after, but before that, there's an unsignaled lane change as.
Yeah, well, I was hoping to see an unsignaled lane change before they even pulled them.
There is, Your Honor, it just,
Show me that.
He said
yeah,
it
it's
was
a freeway, Your Honor. And-
Show me. I didn't see it.
Yeah, well, if I could, I can point out his vehicle.
Yeah. Show me because that's what I was looking for and I didn't see it.
Your Honor, if I may step around, so I can.
Go, please. Come on. Don't be shy.
So it's small, it's at a distance, but you'll see the vehicle come into view momentarily. It's right there. That's the defendant's
That's him?
vehicle. That's the defendant's vehicle. Let me go back a little
There's no way to tell it's.
bit. Because you can continue, no, and you can continue seeing it.
Can you not make it? You should be able to like,
I'm sorry, if we're gonna do crosstalk like this, we can just set this as an MAJ hearing or a formal motion to suppress, and that can be up on the big screen. We can have more structure to an argument, and we don't have to have 3 people arguing about it, or you, that's a personal handheld device.
Yes, Judge.
This is Courtroom Strategy 101. The defense wants a full motion to suppress hearing. Basically, a legal move to argue that the evidence was gathered illegally. If they win, the whole case could collapse. Smart or desperate play?
And that's the.
I guess you want to set up for a formal probable cause
Well,
hearing?
you know, he's on an MAJ out of this court, we just have the MAJ. It's a preponderance standard. They can challenge any motion to suppress they want to, or they can urge any motion to suppress they want.
This is for the new case though, right? This
It
is not for the MAJ.
It's for the new case.
It's for the new case.
Yeah, the UCW.
The UCW, yes.
Yeah,
Yeah, but he's got a pending MAJ in this court for an evading arrest.
right, but because of this,
Right, so this would have to be proved about that hearing anyway.
right, but I mean, I'm not gonna revoke if there's no PC to go here.
Right, I'm just saying if we're going
So-
to be here, having three attorneys talk about a handheld device on the screen and what can't be seen, we might as well just set it for a whole hearing and then we can put the whole video up on the screen.
I'm down. You wanna do it for
Well, that's what-
beginning of next week?
I mean, the court suggested that if there's gonna be.
I didn't realize it was gonna be this
Yeah, I just.
labor intensive, so to speak, you know?
It's turning into like a big argument. If the video is clear enough to determine probable cause, then that's fine. I'm just saying if this is gonna.
I'm having to squint. So that's why, but let's set it for a formal one. Next week, whatever you want. No?
I mean, whatever the court wants.
It doesn't matter to
I mean,
me.
but on the. I would like to do it now if we can, just that willing, but we're in the. I mean, it's the first 8 seconds of it.
He said it's.
The car is so far away, there's no way. The state's gonna point out a minuscule car
You can,
hundreds of yards away, you can't see what lane it's even in.
It's the same.
there, and then the officer continues going in that direction. It's the same vehicle.
Is it that one way over there? It's this one, like,
The one going right at that time. Because it's going right, then the officer continues in that direction, follow the vehicle.
can we see it right here? Which one is it?
So it's not right here, it's
How does he even see that?
because as he's coming around the corner, you see it right there, that vehicle right there going right.
Oh, that was cool how you did that.
Yeah, I don't know how I just. You know
That's great. That's it.
So yeah, as
That's
he's coming
it?
around the corner, yeah, so he's coming around. And then that vehicle going all the way across with no light and then
Look.
Can't you tell what lane he's in?
No. Come here, Will. Look. He hit something that made it like really big.
He can fix everything. No.
You can see him, he's like, hey, he's like, he's cutting off to try to cut out maybe, you know? Mr. Mercer, do you want to talk about something else?
Yes, sir.
Tell me.
Rehashed a previous subject. I was talking to Mr. Martin, the guy who's from San Diego. February 7th, be too late for him to come down here.
It's okay,
Okay, thank you. I appreciate it.
for sure. But, you know, tell him between now and then, he's still not to get, he still has bond conditions that he got from the magistrate. So make sure that he knows that those bond conditions apply, even though he hasn't been here. So, okay, yeah,
I think he'll be okay.
I'm okay with that. Yeah, for sure.
Okay, so is that a finding of PC?
Yeah.
Okay, we address bond conditions then, back to where we were here in the first.
Come up, Mr. Worthy. Can you see if he has a driver's license, please?
Your Honor.
Okay. You're not allowed to drive unless you have also car insurance. Do you understand?
So I have liability.
Okay, good. Don't pick up a third case. If you pick up another case, holy moly, I'm just gonna lose it. Do you understand? Don't. No, you're not supposed to have weapons. No drugs, no alcohol. Did you say there was an odor of marijuana here?
Yes, Judge, a strong odor of marijuana.
Okay, I will test you 45 days from today. If you test positive again for marijuana, I'm going to lock you up. Do you understand? No more smoking weed.
That right there is what we call a judicial warning shot. Judges don't often get this personal, but when they do, it's both compassion and control. Do you think stern talks like this actually help defendants change or just scare them temporarily?
So let's set this off 45 to 50 days. His appearance is required. He will get another test on that day. If he's clean, we'll just continue him and then just goes normal. If he's test positive, get ready. You hold the keys. Do you understand?
Sir.
Okay. All right,
Thank you,
guys. Thanks. Okay. You got to know, your record stands out for itself.
Yes.
No matter what your circumstance is, criminality is still criminality. Whatever you're doing, if you need anything, we can help you here. If you want it, we can give you whatever you need. If you want treatment, if you want a cell phone, if you want a tablet, if you want a place to sleep, if you want to eat, we have resources here that we can help you with. And for as long as I'm here, because who knows how long I'm going to be here, if you ever come back and if you ever want anything, I'll give it to you.
Yes,
All
sir.
you have to do is ask. And I know that the thing is that, like, I get that you want to party, right? And
Not really. I just want to.
just listen, I get it. That lifestyle is going to catch up with you
Yeah.
because, life does not get easier the older you get. It gets difficult. You get
Yeah.
bigger, you get fatter, you get uglier, you lose hair. Life doesn't get easier.
I'm fine.
I want you to listen because you're thinking about what to say. You're not listening and internalizing what I'm trying to tell you, that it doesn't get easier. And I know that you want to get out there. You're ready to get there, go party and just what. If you don't have something, if you don't set yourself up with something, with a skill or some kind of trade or some kind of job or knowledge, you're going to end up lickety split at 50, at 60, destitute, alone, toothless, with no money on the street. Life doesn't get easier. And what you're doing now is you're only hosing yourself worse and worse. It's like we are watching you crumble. And I want to help you, but you just don't want it. And that's okay because you can lead a horse to water, but you can't force him to drink. But it's going to catch up with you.
Yeah.
Don't let it. I'm telling you, in a moment's notice, 10 years is going to pass. And if you keep there,
Yeah. Yes,
you're
sir.
charged with theft. You're facing up to 6 months in jail and or a $2,000 fine. The agreement that you've worked is 9 days in jail, credit for the 7 days that you've done. You have to understand this now makes 2. On the third, you're looking at a state jail felony, minimum of 6 months in jail.
Yes, sir.
And here's the emotional gut punch. The judge lays out the cold math of consequences, a second chance slipping away. Notice how the tone shifts from legal procedure to almost mentorship. It's rare to see such raw humanity in a courtroom setting.
This is it, though. I think this is the last time we see each other, for
Well,
sure.
it is because
Oh, I know, though.
now on, another case, you're going
Yeah.
upstairs to felony court. I'm not going to see you.
Yeah, gotcha.
But this is going to trail you for the rest of your life. Once you plead guilty, you can never take it off. You can never say, you know what? I should have done something else. That's so stupid. Are you sure you want to do this?
Sure.
You don't want to short deferred where we can make minimal conditions. It won't go on your record.
I'm positive I want to do this.
You are giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you plead guilty, there's no changing this. If you ever want something, come back. I will help you as much as I can while I'm here. All you got to do is come back and ask for whatever it is. It is so much that if you want to change this, I have jurisdiction up to 30 days. If you come back, whatever you need.
I'll really put the to it for
How do you plead to the offense? Guilty or not guilty?
guilty.
I'm going to find you guilty. I'll follow the agreement. Good luck. Thank you. Sean, please. Hi. What's up?
1797. This is off docket
Shoot.
254
Okay.
1797.
Harris.
Yes, he has two cases. One, they both have the $100 unsecured GOP bond. One, for some reason, says bond made. We're assuming that was the PR bond on both. And the other one, he's not made his bond. We didn't know if there was some thing we were missing or if we could just make a cash bond so he can bond out.
254-1797. Nice hold.
He does, so we want him to go to immigration so we could get him a bond over there. But
Okay.
he needs to obviously get out here first. So we didn't know if we could make it a cash bond so he can bond out. Or if he
Yeah.
has the PR bond and for some reason
And
it's
if
just
you
not.
want a PR bond?
Yeah, if possible.
So, but here's the other thing is I've got two different people representing him. I've got Carlos Rodriguez on the DWI, and then I have Antonio from the MAC representing him on the FSGI.
Okay, it's our understanding, I work with Mr. Rodriguez, that we represent him on both, so we will need
The
to.
motion itself was never signed, but it's in the queue.
Okay, can you put the motion in seven? All right, I'll sign it. We'll get you on both.
Thank you, Judge.
If you want, I can give you a PR bond. That way that would release the hold. He can get back to immigration.
Yes,
If he makes bond on that,
yes,
we need to know.
yes.
So that way we can have him here. If for some reason he doesn't make bond, just let us know. We can try to bench warrant him back so we can try to take care of everything.
Yes, Judge.
Okay, so let me give you so it's only on one case then, right? The,
The other one, he is
Yeah.
made bond.
so did you get it? The 254-1797?
They didn't give him a deal, they just called it a cash bond or a surety bond. Nothing to prevent him from.
Okay, so I'm not gonna do a PR bond because I can't get a signature. So
Okay.
what we'll do is you guys gotta post just a $100 bond, right? So post the $100 bond,
Okay,
okay? That will release the hold and then it'll trigger him to get back and then just keep us in the loop.
okay, thank you, Judge.
But you have to keep us in the loop because it's gonna get a 7-day setting. And like, I forget so much stuff. Like if it gets on docket and I forget about it, I'm liable to just roll up the bond again because
Yes,
he's
sir.
not gonna be here. So please come back, okay?
Thank you.
Hey, terrible circumstances, man. This sucks.
Yes,
He's supposed to be here.
say it again.
Supposed to be here.
Your Honor, he was actually set for January the 13th, and he was physically here. I had an
I know.
incredibly busy docket, and so by the time I was available, court was already over. But he did make his way here physically from Atlanta on the 13th. And so he couldn't afford a second ticket back to Harris County, but he was physically here on the 13th. And that would be.
How do we know? How do I know it? Let me see. Let me see if I can.
And I believe the coordinator had emailed me too at one point to say, clients here waiting on you.
Hey, Joseph, how are you, man? Happy Friday. So Segumbada's not here. Like you said, the 13th.
Yes.
13th.
He was here.
Was he here?
The reset was signed and he would be here today.
It is,
On the 13th, well, what day is that?
Yeah, 13th on Monday. And Your Honor, he expressed that he couldn't afford a second ticket back in the same week. So I told him I would explain to the court that the reason why he wasn't physically here was by my fault. I just been having.
What
a
do
busy
we gotta
docket.
do something with this case regardless.
Yes.
Where are we
I
going?
understand, Your Honor. So there were some issues with this deal at PTI. Those issues are threefold. One.
He's out. I think they kicked him out.
They did. However, because of the new administration, he does have documentation for justifiable reasons for some of the violations. I spoke to Kelsey Siegler. She said I should be able to speak with Ashley Dice just to review to see if they can just finalize those last bits. Because my issue with Mr. Bada is he actually completed all of the programs. The issues that he has is one, paying $840.
And then the device, though, he was in lockout for a long ass time, wasn't he?
And with the lockout, Your Honor, he had his car in the shop that was where the device was attached to.
No, I think he owed a ton of money and that's what,
$840.
that's why he was in lockout.
Yeah.
On December 20th, it was documented that for the $840 fees, he talking about documentation of financial hardship. And he failed to provide with the device and was unable to provide through the wire of domestic.
Why didn't he even do that?
I have the proof. I have the proof that the reason why he couldn't afford it was because he lost his job.
Get it, but it's always after the fact. Why can't we get it done like when it's supposed to get
Yes,
done?
Your Honor.
And it's,
I'm not hitting on this. I'm trying to desperately get him the right result. Where I'm at right now is either I get this addressed and put him on PTI and get this case dismissed or withdraw, but I don't want to just.
It's, this case is, it's almost nearly 1,000 days old. And I get it that you have really gone above and beyond the call. I get it that you've gone above and beyond the call of duty. And I certainly appreciate it because I don't think you ever thought it was going to be this, you know, I guess time consuming and, you know. I guess if you want to reach out to him, he must have just taken off. He's been in the waiting room the whole
I know he's
time.
been for a while.
So just when he gets back here, we'll.
Yes, Ron.
Stephen,
Morning, Judge.
how are you?
How's it going?
Hey, man.
Oh, wow.
Are you still with the office or no?
No, I'm with the public defender's office now.
Oh, wow, okay.
So we filed a 1109 post-conviction writ. It should be in your queue. It is on, sorry, I should have pulled up the cause number ahead of time.
Well, if it's in the queue, then it's in the queue. I mean,
Yeah, 2001777. We just need you to.
01777.
2001777. 200.
On Simmons,
Yes.
right?
Yes.
Okay.
We just need that signed in order to create the case. So you're not granting the writ or anything at this point.
Did you get it?
I have the application there. I'm trying to generate, because he's not in custody, correct? Or he's.
Correct, he's not in custody.
Yeah.
This is like an old.
What are we doing?
So it's an 1109, so this court has jurisdiction to hear post-conviction writs on misdemeanor convictions. This particular defendant is a person that pled guilty to possession of a controlled substance. Years later, the lab came back that it wasn't a controlled substance. That's our claim.
You're okay with this?
With what
Everything?
specifically?
Just granting no opposition?
We're not asking you to grant the writ.
We're not
at this
asking,
point.
I know, I'm not agreeing to the writ at this point. I haven't looked at it yet.
It was
Um,
filed like yesterday.
But a cause number does need to be created.
And so that's the
Okay,
process. This is all actually this end of this particular process is new to me as well. So
Unfortunately, I don't know why the process for misdemeanor writs is so convoluted.
yeah, you file it into the original case, but a new cause number needs to be generated and then I will sign on to that new.
and then
cause
there's
number.
a waiting period too, right?
So there's a statutory period where you have to rule on it. And so he'll review the writ, essentially file a response, and then we can reapproach or do just filings.
Put in, yeah.
I'm trying to get the right,
I'll sign it, whatever you want me to sign. I'm okay with it. Just, I think he's having a problem getting it in there.
we're generating the setting.
The
date
cause
for
number.
hearing.
No, we're generating a cause number.
Right, so the cause, it won't be under that 200.
Yeah.
777 cause, it'll be under a new cause.
No, yeah, they'll generate, but we, this application writ that we generate.
So you're staying in Ritz?
Yes.
Are you happy? No. Yeah, okay. Because that's good.
Just down here helping out because of the baby
Oh,
teeth.
because of the-
He's supposed to be in court 15 right now, but I ran down here, so.
Go do what you need to do.
So,
Don't worry about it.
no,
We'll
that's
take
fine.
care of
I
it.
mean-
Really. I mean,
That chief, he's got it under control. It's fine.
yeah, I guess you let them know. We'll put it in, I'll sign it, and then we'll generate it. And then, you know, if you guys can agree, great. If not, then just let me know.
Just gotta review some stuff, so.
And I mean, did you get one of those letters that they sent out that says, it should be easy money then? Yeah.
If it is a case where we are going to agree, can I just email you?
Yes.
Okay.
Yes. Right. We don't need to do all the,
He's gonna agree. This is.
hey, don't jinx it, man. You ready?
Judge, we're approaching on a fugitive case. His name is Mr. Alejandro Cortez. Case number is 2547.
I got it.
530. It was for Plaza.
Oh, I see. Got it. I'm assuming you want a bond.
He will let him bond, Judge.
Okay. Are they bringing him out?
They're bringing.
That makes sense, medically
Step
speaking.
away, yes. I mean, escuchen, please.
All right. Good morning, Mr. Cortez. Mr. Cortez, you are wanted out of
Calcasieu Parish, Judge, Louisiana.
residential contract fraud, $5,000 or more, but less than $25,000. Theft from $1,000, but less than $5,000. And thirdly, failing to possess the required license for home improvement. Your lawyer is asking for me to set you a bond. I don't know. I don't know anything about you. I know that you're going to tell me that everything is little sunshine and rainbows and gumdrops, but I have to know everything about you. And so I have Mr. Kim here to help me with that. Please.
Your Honor, Louisiana is requesting that there be no bond until he's returned. However, they have informed me that this warrant, while issued out in 2022, is a 2B warrant and it's not a failure to appear. The remainder of his history is in Harris County, the failure to ID and the assault family member. State just asked that reasonable bail be set at $7,500.
Judge, I would ask that he be allowed to go turn himself in or to procure a bond out there within 14 days. So you won't have to wait here.
I'm okay with giving you a bond.
Okay.
Now is the amount, because
I would ask for $2,000 Judge.
I think that that's just probably a little bit too low.
Okay.
I have to set your bond sufficiently high so that I know you're going to go back to Calcasieu Parish, Louisiana.
Okay.
You have to understand that we don't play games here.
I know.
We give you one chance and one chance only. If I set you a bond and you fail to go back, you need to understand that there are very grave consequences. The consequence is that I'm going to revoke this bond. You will lose all that money and I'm going to set it at zero, and I'm not going to play this game with you again.
Tough love in full swing. This judge isn't just enforcing the law, he's drawing a hard moral line. Fail to appear, and you're done. What's your take? Too harsh or just fair accountability?
You will wait until Louisiana comes and gets you. Do you understand? So once again, let's split the puppy, right? You're asking for 7,500. You're asking for 2. Let's split. So, huh?
Is that 4,000?
I was gonna say 3,500 because I'm not good at math,
I'm
but
not good at math either.
No.
That's, I don't.
so I will set your bond at $3,500. But the only other thing I'm gonna counsel you is, Mr. Cortez, don't wait until the day before to go back, because as Murphy's Law dictates, what can happen will. And I don't care if you break down, if you're a death, I don't care. You understand?
Yes, sir.
Okay.
Thank you, Judge. Thank you, Judge. And,
Yeah. Did you want him brought back up for the withdrawal waiver, Judge?
No, let's do everything now.
okay.
No, no.
Judge, I have a Mr.
Let's be efficient.
Is this a fugitive case or Calabro case?
It's a regular case.
Okay.